Morning, Mr. McGrath.
Good morning, my lord, my lady. I appear with Mr. Legg for Contra the appellant, and Mr. Abinowitz, King's Counsel, and Mr. Polly, King's Counsel, appear for the respondent, Mark Bamford. As the court will appreciate, this is my appeal against the judge's decision to strike out Contra's claim and or to enter reverse summary judgment. It's clearly not my function here today, my lords and my lady, to persuade the court that Contra's arguments are correct and that its construction is to be the one to be adopted, but rather that the judge was wrong to conclude that the case was so hopeless that it ought to be dismissed by way of strikeout and or reverse summary judgment. And in bringing this appeal, we recognise the task that faces us and the need to persuade this court that there is a credible basis for contending that the language used in the document, the touch agreement, and especially paragraph 6, is not to be taken as the last word on the entitlement to be paid the success fee. And we say that when one approaches the situation from that perspective, you do not come up against the arguments of conflict that appeared in the court below, in that it was said against Mr. Hockhauser, who appeared for my client there, on occasions, you've not brought a rectification claim. Are you seeking to give a different view as to what is meant to project Craig Marsh, etc.? Whereas we're suggesting, putting it, that they are not the only criteria for the payment of the success fee. And I'll hopefully go to make good that argument in a moment.
Sorry?
Mr. McGrath, I understand how you open your case, but it's an important point in terms of approach. Obviously, under Part 24 and 3.4, the test is real prospect or is it hopeless? But as the judge recorded at paragraph 53, where he set out the relevant principles for summary judgment and strikeout, if the court considers that it's armed with everything it needs to decide a point of construction, it can determine that outright. And that's what the judge considered the position was, and that's what he did. So in that sense, it wasn't about, is it arguable, one way or the other on the point of construction. He determined the point outright. That led, in accordance with the authorities, to the conclusion that there was no real prospect of success. So as I read it, and I simply flag it up now, you need to do more than establish that it's simply arguable that your point of construction is right. You need to establish the judge was either wrong to determine it outright or wrong in the conclusion that he came to upon such determination.
My lady, I'm grateful for that. I mean, although my submissions at the outset indicated, perhaps incorrectly, the level that I had to reach, the submissions that I made will be made on the premise that we say that our construction
it is really important that you bear that in mind. As I say, the judge set out his approach, and elsewhere in the judgment says, I think I can do this, I have what I need to determine this point, and that's what I'm going to do.
My lady, I'm grateful.
All right. Thank you.
My lord, the court sees that the odd scenario that we've now faced ourselves from the judge's conclusion is that he has found an agreement between the parties, Richard Bamford and Mark Bamford, Richard Bamford on behalf of Contra, on terms that the contract Contra was only to be paid at 2% if a sale of the JCB group went ahead. Now, I point out that that's a conclusion that is not consistent with the understanding of either of the two protagonists to that agreement. Neither Richard Bamford nor Mark Bamford would in fact agree that that is the appropriate conclusion to be reached as to the agreement between them. And if the matter were to proceed to trial, your lordship and ladyship will have seen from the evidence that Mark Bamford would fundamentally challenge the existence of any agreement at all. And we said that's important in this sense, that what happened in front of the judge was a close examination of the 6 paragraphs of the touch agreement. But what would happen in a trial, in reality here, is that there would be fundamental disagreement that there has been any agreement, which, forget whether it's been recorded, there just wasn't an earlier agreement.
Well, can we just be clear what was agreed? I mean, you have to be allowed to agree things, Mr. McGrath. What was agreed for the purpose of the judge's hearing? Was it agreed that there was an agreement? For the purposes of the hearing?
My lord, yes. For the purposes of for the purposes before the judge,
it was agreed there was an agreement.
Yes, my lord.
And was it agreed that the terms of the agreement were those 6 paragraphs written down, signed or unsigned?
My lord, yes. Subject to our arguments about that.
Well, that's what I'm asking. And what were the arguments? Were the arguments that there were other terms of the agreement to be implied by conduct? Or was it just an implied term to be inferred from the factual matrix? I mean, this is what I find, if I may put it this way, Mr. McGrath, when I read your skeleton argument, slightly, I know it's not, I know it's your junior skeleton argument, but it's slightly mercurial. And for my part, I need to know precisely what you say the judge got wrong.
My lord, we say that when one, and I'll take you to it in a moment, when one considers and gives proper weight to the factual matrix and the understanding of the parties, the agreement that's set out in the touch, the terms that are set out in the touch agreement are not a complete statement of the position between the parties.
Now take this slowly. The terms set out in the touch agreement are not a complete statement of the terms agreed between the parties.
My lord, yes, and it's pleaded as brief record of key terms.
I hesitate to rise, but I don't want the court to go off on a false premise.
Yeah.
Paragraph 28 of my learned friend's pleading. That's at
Yeah,
page
let's
169.
just, let me just take time to look at that.
Page 169 behind tab 10.
Paragraph 28, yes.
The terms of the touch agreement were recorded in a document, etc. And certainly before the learned judge, there was no suggestion of any term which mattered, didn't matter, not being recorded in writing.
Thank you.
Mr. Legg can help you, but if you read the judgment, it doesn't appear the judge was being asked to do anything other than construe the express terms of that document and whether or not any term, alternatively, whether any 2 terms fell to be implied. Is that right?
My lady, that is correct, and that's why I'm saying the fact that the case is pleaded on the existence of implied terms, plus it's pleaded as a brief record of key terms, is indicative that it's not covering absolutely everything. That does not mean, my lord, that I'm saying that there's an express oral agreement on a particular term that has not been referred to lordship, but that when one properly understands the factual matrix and applies it to the terminology that is used, the understanding of the parties was that the trigger for payment was the agreement and actual implementation of the separation of the interests under the trusts, and the sale of JCB was a route to that success, but was one of only several routes to that success.
And when you say understanding of the parties, you mean their subjective understanding?
It is pleaded that it was not discussed. It was understood.
Subjectively?
Subjectively understood. Based on the factual matrix which was shared between Richard Bamford and Mark Bamford over the years in the run-up to this agreement.
Okay.
So, I mean, my lord, I mentioned the trial point and how it would be a trial simply to contrast it with what went on before the judge. And as my lady correctly pointed out, the focus of the submissions before the judge were very much on the terms set out in the 6 paragraphs of the touch agreement, and I really was pointing out the oddity of the scenario, that leads to a conclusion that neither party, in fact, was entering. Your Lordship may not...
That may or may not be the case, but it is a function of your having agreed for the purposes of the summary judgment application that the terms agreed by the parties were contained in the touch agreement.
Brief record of key terms.
If you know, and that agreement was is established, and so it may be odd that something else might happen at a trial, but it's a fact what you agreed, and you know, if you live by the sword, you die by it.
My Lord, I agree, but the reason I mentioned it was only that when one then looks at what the position would be at trial, one is left with a completely different position, and that should cause some cause for concern. But I take on board, I'm not trying to withdraw the concessions that were made before the judge.
Can I just clarify one point? I haven't picked up in the pleading this point about brief record of key terms. Where do I find that?
I do apologise, my Lord. Well, I'll get to... Well, whilst we... If I can...
It's page 168,
Yeah, G.
subparagraph 27.5G.
Yes. Thank you, my lady. 167.
Yes, I see.
But it,
And of course, it said against me on that. Well, presumably what you say, Mr. McGrath, is the way we should interpret the agreement would be a key term and therefore would be set out. And I say in response to that, I have my explanation as to why it was set out as was, namely it's the layman's reflection of the discussions that have taken place. But even the position the judge found himself is not a position that directly arises out of a key term set out in the agreement. And I hope to make good that argument. I'll say it now, and that is that Project Craig Marsh he interprets as the sale of JCB having taken place, and that being the trigger for the payment, when the agreement itself on its own terms doesn't say that. And we'll go to that in a moment.
I think that the point that it is important. I don't think brief record really helps you. It may be brief, but it's a record of the key terms agreed. There is no pleaded allegation of any other contractual terms agreed. The only contractual terms before the judge were those in the document, briefly noted or otherwise. Is that fair?
My lady, that is fair, which is why I started off by saying we recognise the task that is before me in persuading the court of the position, but that we say that once one recognises that we are dealing with an oral agreement that was set out in writing, but in a one-page document, 6 paragraphs that were not the benefit of any commercial law lawyer's advice. The drafting wasn't undertaken by any lawyer. And we say that you ought to, as we set out in the skeleton, give a great deal of leeway to the factual matrix relating to what the parties did in fact agree, leading to those terms being set out.
I mean, obviously, the paragraph you've just drawn my attention to, at whatever it is, 127.5G, is part of a paragraph dealing with implied terms.
Yes.
And then one finds in paragraph 28, it said the terms were recorded.
Yeah.
Yes, my lord.
And the agreement was concluded as follows at the beginning of paragraph 27.
Lord, my lady, we say that one approaches this document as it is. It's a one-page unsigned document. The judge saw significance. We say it's telling from his comment in paragraph 56 of the judgment. He saw significance in the fact that Mr. Richard Bamford was a professional, a chartered accountant. And we say that, and he said it was important to note that. And we say, with respect to his lordship, that really does show a flawed direction of travel, because the fact that Mr. Richard Bamford might very well be a chartered accountant and a professional in that sense says nothing at all about abilities to draft, any more than my being a professional lawyer says anything about my abilities to undertake any auditing of a company or business. And in fact, the mention of that by the judge indicates from the outset a flawed direction of travel, we say. Because it was important, but it was an important point going in the other direction, one that should give some recognition to the document being drafted by a non-lawyer, reflecting how things have been said to him in discussions with Mr. Mark Bamford. Now, we say clearly it's key for the court's understanding to appreciate the background and the factual matrix that has led to this agreement being reached. And the court would have picked up from this from its reading that there were 4 family trusts in which the interests of Mark Bamford and Mark Bamford and Anthony Bamford were, if I can use the language, commingled, in that each were beneficiaries of each of the 4 trusts, notwithstanding the terminology that they are Mark Bamford 1 and 2 and Anthony Bamford 1 and 2. But from the early days after the death of their father, Mark Bamford had wanted to disentangle his interests under those trusts and in the family business. And the judge noted in paragraph 12 that negotiations for a potential sale in 2005 had taken place. And as we plead at paragraph 13.1 of the pleading, Mark Bamford had concerns about possible related party transactions leading to corporate governance review. I don't wish to get into any of the details of these points, but they're an important background as to why it was a key issue between between Mark Bamford and his brother, that there be a separation of their interests under the trusts. And that Richard Bamford was the key advisor from at least 2006, 2007 to Mark Bamford on that key issue. And that his task was to provide advice and services to Mark Bamford in respect of securing the emancipation of his financial interests under those trusts. And as part of his reason why that was so important was his concerns as to how the business was being handled, which led to the various strands of litigation that the court will have seen mentioned by the judge, both in Holland, in Bermuda, by the trustees, and a couple of occasions here in England. And Richard Bamford played an integral role in advising Mark Bamford about protecting his interests and securing the eventual agreement to separate those interests from that of Mark Bamford under the trust. And if I could just show you 2 paragraphs of the particulars of claim, paragraph 22, which is at Core Bundle tab 10, page 165.
You haven't got a Word copy of the particulars of claim you could let us have at some stage electronically.
I'm sure my junior could get hold of it.
Yeah, it's just it's a copy that's quite difficult to highlight and search in.
I apologise, my lord.
I may have a Word copy. I'd appreciate it. Yes, paragraph 22.
So we have paragraph 22, In light of the above, the defendant and Richard Bamford, on behalf of the claimant, negotiated and agreed to compensate the claimant and Richard Bamford for past loss of fee income of approximately 4.5 million, and for Richard Bamford to provide his future services in relation to the settlement of the litigation in preparation for an execution of Project Craig Marsh without payment of further hourly fees, in return for a fee of 2% to be paid to the claimant on completion of Project Craig Marsh.
So what's the date of this allegation?
The
I don't mean the date of the particulars of the claim. I mean, when is it said?
If one turns over the page to 164, turns back page, it's 10th of June 2011.
So this is all the 10th of June.
Yes. And your Lordship may, and the Court may have read on to the end of 22, where it says, as noted in paragraph 13.6 above, while the sale of the entire JCB group was understood at the time to be the intended divestment of MB Trust assets, since other forms of divestment and restructuring had been the subject of prior consideration and remain possibilities, it was understood, albeit not expressly discussed, I point out that the 2% fee applied to any other such arrangement upon completion. The defendant and Richard shook hands on this agreement. And then we have 27.5, which is page 168, and he says the pleaded case is in the context of an implied term, but it says the separation of interests of Anthony Bamford and the defendant, Mark Bamford, had always been at the centre of the issues between them since they'd reached the settlement in 2004 with somebody else.
So what happened on this pleading then to the agreement pleaded at paragraph 22?
That then...
So there's an agreement, an oral agreement, on which they shook hands on the 10th of June. They then, Mark rings Richard to discuss the mechanics for separating interests later. There's a telephone call. And then they met again.
In a nutshell, my lord, but I'll be taking you to one or two of the underlying contemporaneous attendance notes. You have the agreement of 2% fee. Then you have Mr. Richard Bamford being told that he needs to take a step back. He wants to be protected for the services that he's provided to date, and an agreement is reached for an advance payment of those services of 2.6 million. And then that is to come out of the 2% fee when the 2% fee is paid.
But in answer to my lord's, the Master of the Rolls' question, though, I mean, what happened to this event on the 10th of June, there was never a claim brought by reference to any agreement reached on the 10th of June.
No, that then morphed into the...
So it is the answer. It's the build-up, you would say. It's relevant factual matrix, but that's all that it ever was before the judge.
Certainly, that's how it's been pleaded, my lady. I'd have to accept that.
Right.
Well, I don't understand the word morph. I don't understand how agreements
Well, there was an agreement.
They're generally varied,
My lord,
or terminated, or breached, but not morphed.
it will be varied, my lord, in order to incorporate the £2.6 million advance fee payment to be deducted from the 2%, and then you will see that reflected in the terms of paragraph 1 and paragraph 6.
There was never a claim brought by reference to an agreement on the 10th of June varied.
No.
If you look at, sorry, Mr. Rabinovitz probably can put me right, but I mean, if we look at the performance of the Touche Agreement, 32, repudiation of the Touche Agreement, etc., it's all about the document. The Touche Agreement document.
It is, my lady.
So just to be clear, at the beginning of 27, we see it said that the parties finalised the terms in the touch agreement. I suppose there are then two possibilities. Either there was an earlier prior agreement which was varied, or at the earlier stage there was no contractual agreement, and then it's given preceding discussions, which were non-contractual, become the touch agreement.
My lord, yes, there is two alternatives, but
Well, which
What's
is
your
it?
case? Sorry.
well,
You see, I'll tell you what bothers me is I see all this sort of, if I may be rude, not intentionally, a slightly loose pleading. But we're all lawyers. You've just emphasised that in your submissions. And lawyers have to have some parameters of certainty. Now, you've pleaded an agreement, and I know you didn't plead it, but there is an agreement pleaded. And as my lord says, I've said and he said, something's got to happen to that agreement if it's relevant at all to have pleaded it. It's either amended to become the terms of the touch agreement. Is it touch or touche?
I'm saying touch, but
Yeah, it's my fault. I keep saying touche.
Well, I mean,
Don't know
touche is
why.
a firm of
I know.
accountants, I always thought.
North of Watford we call it touch.
Okay, maybe. But it's either amended, in which case it may or may not be even admissible background to the terms of a written agreement. It doesn't seem to me to be relevant and consistent with paragraph 28. 28 says the terms of the touch agreement were recorded by the claimant on the 30th of June in a document dated and which RB gave. This document, same document brought to the bar. The terms of the touch agreement were recorded as follows and was not conditional on signature.
Well, can I just respond to this? The concerns that the court is expressing is, in my respectful submission, a reflection. We'll put to one side any pleading points, but it's a reflection of the factual scenario which led to the touche or touch, now your lordship's got me saying, the touch agreement, in that, whilst as lawyers we like to have clear categories that we can put things in, when lawyers aren't involved and you're dealing with non-lawyers, things aren't as clear and as straightforward. And these parties, unadvised by any lawyers, have reached understandings in the run-up to that agreement and are asking the court, or at least one side is asking the court.
I'm not doubting any of that. What I'm seeking clarity about is the terms of the allegations made in the pleading which you will seek to prove at the trial you want us to permit. And at the moment, I don't completely understand what is the relevance to what the judge had to decide of the allegation that there was an agreement on the 10th of June in different terms to those contained in the agreement of the 1st of July.
Well, it's the stepping stone to the agreement that was ultimately reached as to the 2.6, which is reflected in paragraph 1.
It is the stepping stone to a written to terms that are
Is it? But
relevant.
my lord, is it fair to describe this as a written agreement between the parties in the same sense as one would describe the 6th of the March 2014 50-odd page agreement?
That's precisely my question.
And we're
Because
saying
you
now,
plead that the terms are these terms, and you agreed for the purposes of summary judgment that the terms were these terms, subject to any implied terms. What's the relevance of the previous agreement?
well, that is part of the shared understanding of the two protagonists who reached the agreement on that's set out in the unsigned document. And
shared understanding that.
well, it's if we go through the as I've indicated, the 2%, and then there was an advance fee payment, and I'm going to come on to look at the actual terms of the touch agreement, but the advance fee payment of 2.6 million coming out of the 2%, and that being in respect of historic services. Now, well, maybe I can jump straight into that point.
Just before you do, I would like to be clear about what the relevant shared understanding was. I mean, there are two things. A, you're presumably talking about subjective understandings, but when you say shared, you presumably mean crossing between them.
Yes, so if you look at 22, my lord.
What was this understanding that they shared between them?
Well, as it says, that there had been several different attempts in different ways, and it was understood and not in dispute before the judge, that there were several different ways upon which, and maybe many ways, upon which one might secure the separation of interests, which is reflected in the second half of 22.
But my lord, quite rightly and understandably, referred to crossing the line. But we know from this pleading that this shared understanding did not cross the line because it was not expressly discussed.
It was not. What was not discussed was there was no express agreement, and I'm not departing from it, as to the alternative, any alternative route to trigger the 2%, but that formed part of the shared understanding because both Mark Bamford and Richard Bamford were well aware of and had experienced lots of attempts to do that, and they were all still potentially on the table as viable routes to secure the separation of the interests.
So to be clear, the shared understanding was that there was more than one way in which the interests could be separated.
Yes.
I see. But not that the 2% applied to any other such arrangement.
Well, you'll see that obviously Mr. Richard Bamford is of the view that would follow because the key issue, a measure of success, the benchmark of success here is the achieving of the separation of the interests.
But just to repeat, your answer to my lord is the shared understanding, part of the factual matrix, which the judge accepted, was that the parties understood there was more than one possible way of separating the interests.
Yes.
No more and no less.
Yes, my lady. So if we were to turn to the document itself, at page 181, Core Bundle tab 11, 181, the court will see, when looking first at paragraph 1 and 2, there's a theme running through the interpretation of this arrangement to distinguish and keep clear any payment under paragraph 1 from any payment under paragraph 6, so that payment under paragraph 6 can be properly viewed as a success fee as traditionally understood, whereas on this approach paragraph 1 is to be seen solely as a payment for previous services. But when one looks at paragraph 1 and 2, the first thing to note is that it is crucial to understand what the settlement is. It doesn't define the settlement in this agreement. So from the off, one is having to look outside of this arrangement, these 6 paragraphs, in order to determine what it is the parties were agreeing.
Why do you need to know what the settlement is? I mean, that's a given.
Well, is it?
Well, the payment of 2.6 million didn't depend on knowing anything about the settlement. It's accepted that that's happened.
Well, yes, but what has happened?
But it's just the date that matters. It's the services up to that date.
Yes, but if the 2.6 million is paying for services relating to the agreement to separate interests under the trusts, and if those services form part also going forward, then there isn't a distinction between paragraph 1 payment and paragraph 6 payment that sought to be drawn by my friend in his interpretation of the agreement, that there is a connection between the two. The 2.6 million is seen as being an advance payment of the 2%. And we see that when you look at paragraph 6, where it makes it quite clear in the last line. You get your 2%, less the sum paid under paragraph 1. So we know, and we know that 2.6 is an advance payment that was brought about or agreed because he was asked to step back, and that's an important point when one comes to interpret whether or not the success fee in paragraph 6 is indeed a true success fee, as would be understood in, say, a case such as Barton. And then one looks at paragraph 3, and one can see how project Craig Marsh is defined. And I hope that my Richard Bamford won't mind me saying, but it's a bit of a dog's dinner, the first sentence of paragraph 3. Mark Bamford will continue to privately brief Richard Bamford on progress towards that completion, and in addition, the steps being taken to prepare the JCB Group for sale in 2012, brackets project Craig Marsh. There are various different ways one could look at that, one of which we say is that it's actually defined as the steps being taken to prepare the JCB Group for sale, not the sale.
Well, there's another point, isn't there? In paragraph 2, the first use of the word complete is referenced to the 17th of June settlement between Mark and Anthony, right? And then it says, MB will continually to privately brief Richard on progress towards that completion, namely the completion of the 17th of June settlement between Anthony and Mark. And in addition, the steps being taken to prepare the JCB Group for sale in 2012. So I'm assuming that Project Craig Marsh is only defined by reference to the words, in addition, the steps being taken to prepare JC Group for sale in 2012.
As opposed to
both of them.
Adding the first few words to that as well, which is why I
say that.
I'm making my point on the one your lordship has, which is the steps taken to prepare.
Yeah, but you say steps taken to prepare is not the same as sale.
It's not the same as sale, but the point's even further removed if one says the Project Craig Marsh is the definition of what's gone on in that whole line.
But I know, but which do you say it is?
I'm putting that it's more likely to be the steps being taken to prepare the JCB Group for sale.
So, and more likely is a bit difficult, but anyway. So you say project...
What it doesn't say, my lord, is Project Craig Marsh means the actual sale of JCB.
Was that an argument run below?
I don't believe it was, my lady.
I mean, I know you're going to come to this, but does it actually matter when under 6 the success fee is payable on the completion? So it doesn't really matter whether Project Craig Marsh includes the steps taken prior to completion, because the success fee is payable on completion.
But when one looks, perhaps I could show you a note which indicates some of the steps that are at play in implementing the settlement or separation of interest and also the sale, which did pass between Richard and Mark Bamford.
But is it your case that the success fee was payable otherwise than on completion of Project Craig Marsh, whatever Project Craig Marsh was?
We say that the completion of Project Craig Marsh is one of the routes and was the expected route by which the separation of interest would be achieved.
Yeah, so it's the sale of JCB? Is that how you read completion of Project Craig Marsh in
No,
paragraph
completion.
6?
No, because on completion of Project Craig Marsh means on completion of the steps taken to prepare JCB for sale.
That is a completely new argument as I read the judgment anyway. Has that been run anywhere?
No, my lord, my lady.
And because you've said what you have in paragraph 3, Project Craig Marsh must mean the steps and not actual sale. You now say that completion of Project Craig Marsh means the completion of the steps being taken to prepare the group for sale.
The point being made here, my lady, is that one needs to look outside of the four corners of this agreement for an answer that Project Craig Marsh means something specific such as sale, and that the judge's own reading of the words as used doesn't get him to where he concluded them to be, namely a sale, which is important because he then used, as I'll show in a moment, the association with sale price under 2% to justify denying any other event being a viable event to trigger the 2% sale. And so what I'm saying is that connection is wrong at the beginning and it isn't supported by 6.
Can I just clarify a little? I think you say Project Craig Marsh isn't just a sale, it's a separation.
In order for it to be in order for it to be successful, it is one route available. But just simply selling on its own may not achieve the separation, because the separation involves the unmingling of the interests under the trusts.
Well, that might be a point against you if you have not only to achieve a sale but a separation. But let's assume for the sake of argument that one way that you could achieve Project Craig Marsh was a sale, which I think is common ground. Is it your case that, supposing that was what happened, the success fee became payable before the sale because the steps taken to prepare for it had been completed?
I think it would have been earned, but it wouldn't have been paid, because one would no doubt be looking to the sale price, the actual money being generated by that, in order to meet the 2%.
Okay.
But the liability to pay would have arisen before any sale.
Yes, on definition in paragraph 3.
Can I come back to the dog's dinner that you described your client's drafting in paragraph 3? There isn't any particular reason why Project Craig Marsh is to be taken to be the second rather than the first part as well. If it were both, does that help you?
What that then shows, it's further support for our contention that the 2% is not a success fee as traditionally understood, and it's a recognition that it is a payment where the measure of success, as we say it is, based on the understanding of the parties, measured by reference to achieving a separation of interests, this being simply one way of doing that, but there being other ways of doing it.
And so is that an argument ever advanced before the judge? That it was both rather than just the steps taken to prepare?
I don't believe, my lord, I don't believe this passing of paragraph 3 took place before.
I mean, you described it in that pejorative way, but actually it's not difficult. It's got two parts to it. One is that MB will continually to privately brief, with a split infinitive we have to comment on, Richard, on progress towards that completion, the completion of the 17th of June, and in addition, the steps taken to prepare the JCP group for sale. And that's what's described as Project Craig Marsh, which seems at the very least to me at first sight to be ambiguous anyway. I mean, nobody really suggested there was much ambiguity in this agreement, but that seems to be
My Lord, I mean, I'm somewhat late to the party here, but the approach I've adopted is that when one's looking at such a short document and the background, and then you look to see, is the document as clear as the judge seemed to think? One of the factors he relied upon was the clearly defined trigger event.
Which paragraph is that in his judgment?
My Lord, I'll...
Look, while my learned friend's looking for that, again, I hope save time, and I genuinely hope to be helpful. My Lord, the Master of the Rolls asked whether this argument about paragraph 3 was run below, and it wasn't. And there's a good reason for that. If you go in the pleadings to paragraph 13.6 on page 162.
Is this the generic?
The sale, it's that paragraph,
Yeah.
about 4 lines.
So which page is it?
Page 162. It's just the definition of Project Craig Marsh, which you find there, which is the basis on which we will proceed below. The sale process had been given the code name Project Craig Marsh. And it's not only that, I mean, throughout the pleading, if you go, for example, to paragraph 27.6, where the pleader is talking about Project Craig Marsh, also implied term that if Project Craig Marsh or some other form of divestment or restructuring, so again, plainly understood to be a form
Well, that
of
was my
divestment.
understanding. What did the judge say, Mr. McGrath? Where's the judge deal with this?
The clearly defined point.
I mean, paragraph 57 is the answer to my question. I'm sorry, I shouldn't ask questions I know the answer to. Where he says, as a matter of analysis of the contractual text, there can be no doubt that Project Craig Marsh refers only to the proposed sale of the JCB Group. Now, there is no appeal against that finding, but I was putting to you that at first sight it appears a little doubtful. But you don't say that. It's not part of your case here.
Well, my Lord,
Because it's contrary to your pleading, apart from anything else.
Lord, I'm raising it to show the document isn't as clear as the judge said it was or thought it was. So
I mean, the problem with just saying it's not clear is that we deal here in absolutes. We have grounds of appeal, Mr. McGrath, and you've got 4, which you've been given permission to argue. And you can't depart from them with very sort of, if I may put it this way, airy-fairy submissions without leave. So, we need to know. I mean, I think the answer to my question must be this case has been argued on the basis that Project Craig Marsh means what you say it means in the pleading and what the judge said it means in paragraph 57, and there's no appeal against that, so I can forget my point right or wrong. Is that right?
my Lord, whilst the observations on the language remain true, your Lordship's conclusion on the way the case can be put is true.
That's a yes, right?
It's certainly a yes for the second one, but without forgetting the first one.
I mean, there will have been a shared understanding on this, won't there? I mean, Mr. Richard Bamford was in a position to use the term Project Craig Marsh, doubtless because he had got it from Mark Bamford. And on that, they will have had a shared understanding, which presumably is reflected in the pleading.
Yes, and just picking that point up, if I may, my Lord, that we say that the reason it's reflected in the agreement is precisely that, namely that it was the forerunner of the route, the manner in which the separation of interest was expected to be achieved. And so it was reflected in the agreement because it was the forerunner, not because it was understood as to be exclusive and only means by which one could separate the interests and succeed for the purposes of qualifying for a trigger. And can I just show you?
Just before you do, I mean, paragraph 13.6, to which Mr. Rabinovitz took us, says that the term Project Craig Marsh was a code name. It was a code name presumably in use within the Bamford family, within JCB. So that's what they will have understood it to mean, won't they? Well, that they will have understood it to refer to the process that had that code name.
Yes, except that's not the way. It just can I just stand back and say this one? That the wording in the actual agreement, I'm being, or my client is being asked to be held to the wording of paragraph 6, and it says specifically something, and we're not going to go beyond what it says there. But when we come to look at paragraph 3, we seem to be happy to discuss shared understandings and code names and what have you previously understood between members of the Bamford family. And so I would just simply say, Lord, that, I mean, it was run, the argument was run, but rejected by the judge, that there was a wider understanding to Project Craig Marsh. We will pick that up, and there's no appeal against that.
Sorry, say that again. The argument was run.
The argument was run, but rejected by the judge, as that Project Craig Marsh was a generic term for the separation of interests.
Well, you pleaded that,
Yes, and that,
didn't
that
you?
was
Paragraph back on page 162, 36.
and the judge rejected that, and there isn't an appeal against that.
Sorry, he didn't reject as a matter of fact. Where did he reject as a matter of fact that last sentence?
He said that it didn't, given, I hope I'm not wrongly paraphrasing, but given the understanding of Project Craig Marsh being a sale, he didn't think that added to it, to his understanding of what the parties understood Project Craig Marsh to be.
And which paragraph did he deal with that point in his judgment?
We'll get that. But
66.
66.
Is it 64 or 65?
It's at 66.
Yeah, 66.
To 66 to 68. The context, and again, if I'm not being helpful, please do tell me to sit down. But the context in which the paragraph 13.6 point arose below was not in the context of the interpretation of paragraph 6, but it was in a consideration of the factual matrix and whether that comment about what Mark might or might not have said, we accepted it obviously for the purposes of the hearing, could be relevant factual matrix. And the learned judge's conclusion, I think between paragraph 66 and 68, was that it was in the form of inadmissible negotiation, and even if it wasn't an allegation which was advanced with anything like conviction. It was inconsistent with what was said in this pleading, in the contract, in 3 previous pleadings.
Mr. Rabinovitz, you're going to have to speak up a bit because you've got a bit of competition outside, and also I think we must let Mr. McGrath make his argument.
Yes, he rejected at 67 the private dictionary meaning of it. But can I just take the court to one document, if I may, and it's the supplemental bundle, tab 10, page 65. And this is a note that was prepared by Richard Bamford on the 15th of June, following having been informed by Mark Bamford as to the agreement having been reached to separate interests in return for dropping of litigation. And then on the 16th of June, Mr. Richard Bamford went through this with Mark Bamford. And one can see separate trusts going forward for A, B and NB, change the trustees now, change protector in due course. And you see under the first paragraph, clause 1.1, the idea of being principal beneficiary status and sorting out the lineal descendants so that the trusts are separated. And then just under clause 1.2, you'll see need an agreement between Anthony Bamford and Mark Bamford trusts to commit to Project Craig Marsh, and then keep flexibility for a plan B should Project Craig Marsh fail. and then you'll see implementation, and then there are other headings. There are 7 work streams which arise out of the agreement to affect the separation of interests that had been, as we had been told, my client had been told, had been agreed the day before on the 14th. But it says Plan B. Now, we pray that in aid of the fact that the key issue here, as revealed in this document, but also the other documents, is the separation of interests and affecting that. Project Craig Marsh keep flexibility for a Plan B should that fail. So we say that it isn't and wasn't intended, as evidenced by this document, which did pass between Richard Bamford and Mark Bamford, to be the sole means by which one got to the separation of interests.
I think the judge accepted all that. He said it was a point against you.
Well,
The party, that there was more than one possible exit route told against you in circumstances where the parties had chosen to agree to payment on completion of the sale, i.e. Plan A, not Plan B.
That my lady is right, because
that was his approach.
His approach was premised upon treating the success fee as a traditional success fee that you either succeed on or fail with, and if you fail you don't get paid. And so his view was whatever the range of options that may have been available, one has been chosen, and therefore that is the only one.
Yes.
Whereas I'm looking at this and saying that the understanding between the parties was not that Project Craig Marsh was the key factor. There's a plan. Why would you have a Plan B or need a Plan B or the requirement to keep flexible if the plan, Project Craig Marsh, was the be-all and end-all of your arrangement to be paid the 2%?
And you say this is a document that's relevant and admissible for construction purposes, and looking at it, going back to my Lord the Master of the Rolls questions, do you still say that Project Craig Marsh means steps building up to as opposed to sale?
My lady, my point on that was to highlight the paragraph 3 didn't say expressly what the judge said, and that one would need to come outside of the 4 walls of the arrangement in order to understand what Project Craig Marsh means. So one is not looking, he said it was a clearly defined a term and trigger based on the sale, but paragraph 3 doesn't say it. But my lady, for the purposes of this appeal, it doesn't matter whether Project Craig Marsh means an actual sale or the steps taken up to the sale. It plainly includes steps taken up to the sale, even if it in addition includes the need for a sale. What's central to the argument is an understanding that the benchmark of success is not necessarily Project Craig Marsh alone, but that other possibilities were available so long as they achieved the aim of the actual separation of the interests under the trusts. And that, my lady, that doesn't require us to say Project Craig Marsh means something different, which was some of what went on, I think, before the judge. And the question, well, are you not trying to rectify Project Craig Marsh or what have you? It's simply to say it isn't everything, given their understanding based upon the other options that were available and the importance of the separation of interest being the true benchmark for determining the success of the arrangement and the success of the services provided by Richard Bamford. Now, we say that contrary to the judge's finding in 83 of his judgment at page 106, forms no part of the terms of the touch agreement that any form of the restructuring must itself involve an evaluation of the shares themselves. And this we say this is part of reading in that it's to do with solely a sale price from which one gets the 2%, and if you can restructure in other forms that do not involve the sale or valuation of the shares, then those could not be intended or contemplated by the parties under paragraph 6. And the point we say is that, as a matter of fact, it's likely that other forms of restructuring which succeeded in separating the interests of the parties under the trust would involve an evaluation, because there would be a separation of the interests and therefore likely to be, but doesn't need to be, an evaluation as part of that process. But my bigger point is that the paragraph 6 doesn't tie the evaluation process to the sale. It's an evaluation process which can and no doubt does take place for reasons other than a sale. And if one wanted and felt the need to put an evaluation or valuation on the shares for the purposes of the 2% fee, the fact that the restructuring that led to the separation of interests did not itself require that process is not a reason for disregarding it under paragraph 6.
So that is a point of interpretation, is it, that you say the judge got wrong?
Yes, but it's a point. It is, my lord, but it's also it's a point that is used to reject the argument that the benchmark for success could be anything other than sale, by rejecting the fact that other forms of restructuring may not involve a process of evaluation. So it's bolstering the argument in favour of, as found by the judge, but also rejecting the possibility that the parties could have been contemplating other triggers for their 2% fee. It's similar, my lord, to the points made about paragraph 4 on page 181 of the agreement, where there's a reference to third line up from the end of paragraph 4, or when the beneficiaries of the trusts are first consulted on the project Craig Marsh plan. The judge in paragraph 58 said that is further support that this arrangement is all about a sale and not any other form of restructuring of separation of interests. But with respect to his lordship, the beneficiaries of the trust are beneficiaries of these are not the principal beneficiaries, Mark Bamford and Richard Bamford. These will be the lineal descendants certainly of Mark Bamford. These are discretionary trusts, so they don't in fact own the shares, and so it isn't obvious that there would be consultation with them about the sale of the shares as a necessary step. But going back to our document on the 15th of June in the supplemental bundle, tab 10, paragraph, page 65, one sees there the need to remove the lineal descendants from the trusts. So within the context of paragraph 4 and the Dutch agreement, you can see that the steps necessary to separate the trusts are to be found referred to. Similarly, my lord, in paragraph 6, and the reference to, in the parenthesis on the second line, or if applicable, any replacement trustee of the MB1 trust.
Okay, sorry, just going back, I'm not sure I have grasped that first point. So in 1.1 we see MB plus spouse and his lineal descendants to come out of the AB trusts, and AB, CB and his lineal descendants to come out of the MB trusts. So,
Yes.
so the idea is that each limb of the family should simply
Yes. So
have
MB
one
trust will
yes.
have just MB
I follow.
as the beneficiary at the end of the day.
Yep.
And some of the material that your lordship and ladyship would have seen in the confidential bundle made reference to concerns about whether or not beneficiaries would consent to move, and if they didn't, the suggestion that it all would be null and void. And we say that is reflected in paragraph 4 by the reference there. But the judge saw that as being pointing to his conclusion it's all about the sale and not about the separation of interests, whereas we say that the consultation of the beneficiaries has got nothing to do with the sale. And the
Sorry,
reference...
I'm being slow. Why does the consultation with beneficiaries have nothing to do with the sale?
Well, because they need to be consulted in order to be physically moved to separate their interests. But the sale, they're not the owners of the shares. These are discretionary trusts. So the deal would be done at a different level to them. Because they don't own the shares that are being sold.
While we've got this document, the next one, 1.2, refers to TESN level. I'm afraid I can't remember what TESN means.
That I was told that I did actually ask that question myself. I believe that is a parent company. It's the holding company, Transmissions and Engineering Services Netherlands.
Yes, that's it.
And I was just going to make the same point briefly in the second line in parentheses in paragraph 6, or if applicable, any replacement trustee. The need to replace the trustees being consideration 1 in the document that's on the 15th of June. And again, that we'd say would point very much towards having in mind the separation of interests under the trusts. At paragraph 88 of the judgment, page 107, the judge rejects, or one of the arguments in favour of rejecting the contention that it's other forms of restructuring is on the basis, he says, that, well, we don't know what the skill set is that might be required for that other form of restructuring.
So what paragraph?
Paragraph 88,
Thank you.
page 107. And he says, we don't know what the skill set is that would be required, so we don't know whether Richard Bamford's skill set would be necessary for any other form of restructuring, and that, and if so, how much of a role he would play to see whether or not it's fair remuneration. Well, the court will see in a moment when I come on to look at the touch agreement in more detail on this point. We say the judge is clearly misunderstanding the touch agreement if he thinks that the 2% fee is premised upon any consideration of detailed involvement in the sale process of the JCB group, and that it's been understood that his skill set is one that is necessary for the sale process, whereas we argue it is all about the services he has provided in respect of leading up to the successful agreement to separate the interests under the trusts. So we say that that's simply not a relevant inquiry, but it's one that the judge refers to, in order then to debunk the suggestion that an alternative form of restructuring is one that's on the table, or could be on the table.
Sorry, he's dealing with an implied term here, the first implied term, and the officious bystander test.
Yes, yes, my lady. But he's one of the ways he's rejecting that argument is to say, but we don't know what the relationship would be between Richard Bamford and any other form of this restructuring that you referred to. And we don't know whether 2% would represent a fair remuneration for that involvement. We don't know whether or not, in fact, he could have any involvement.
But why is that not, I mean, just looking back and standing at the O of course test, why is that not a legitimate thought process?
Well, because it's not a process that drove the 2% fee under the terms of the touch agreement itself. And maybe I can go and make good that point if I can, by showing that we say that the success fee in paragraph 6 is not your traditional understanding of a success fee. Firstly, contrary to the judge's conclusion at 82, we don't accept that the touch agreement defines the success fee as being 2% of the sale price. You've had my submissions on that it is a process of evaluation which stands independent, or can stand independent, and is not necessarily connected to any such sale. But one can see that by putting forward an argument of a close connection between the 2%, the success fee, and the actual sale price, what the judge is doing is falsely suggesting greater distance between that fee and events other than the sale, and we say that's just simply not the right approach.
And it's just to help me, is this ground 1, 2 or 3?
My lady, this is the interpretation of success fee, which I think is ground 3. Yeah. And so we say it's not a traditional understanding of success fee. And we say that a success fee is an incentivized payment to an individual to pull out all the stops, and should they achieve the stated outcome, then they get paid that fee, which is often an inflated fee. And if they don't, then according to Barton and Morris, they won't. But if one looks at cases such as Barton, Mr. Barton there is an individual who has charged with the responsibility of introducing potential purchasers. And if he introduces a purchaser, and if that purchaser goes on to agree a sale price of 6.5 or more, then there is success. Success is measured, obviously so, by reference to achieving the 6.5 million or more sale price. And obviously anything less than 6.5 million would be considered a failure, flip side of success, and in the eyes of the majority in Barton would exclude payment for a lower price. And similarly in Cutter and Powell, a completely different type of case, as interpreted in Barton, that was a case in which the second mate was given an incentive to stay the course, the 2 months of the journey between Kingston and Liverpool. That was, and his incentive was to receive 30 guineas if he did that. And if he didn't, then he didn't get paid. But we say that the 2% success fee here stands in a completely different light to cases of that nature. Firstly, we make the general statement, which is that success here, in terms of the relationship, the advised relationship between Richard Bamford and Mark Bamford, is not measured by the sale. of JCB, but is measured by the agreement to separate the interests under the trusts. That's how one measures success in Richard's provision of services. And to elevate the sale of the JCB as the indicator of success is to ignore that fact which arises from the factual matrix. And
So that is a matter of construction of the phrase success fee on the completion of Project Craig Marsh, or implication of a term?
it is construction of success fee based upon the understanding of the parties. But if I'm wrong about that, that it's implied under the officious bystander test.
Well, you know, I'm still bemused because I still, if you're trying to expand what Project Craig Marsh means when paragraph 6 of the agreement says a success fee will be paid on the completion of Project Craig Marsh, then surely the only logical way to do it is to interpret the first sentence of paragraph 3 differently from the way you always have. I mean, because, I mean, I could, you know, I mean, I don't want to be difficult, Mr. McGrath, but if you read this agreement, it's got a structure to it. The first paragraph is about the payment that's to be made for the past up to the settlement. The second paragraph is about what's going to happen to Richard, what he's going to do in the future, and the completion of the settlement agreement. The third is what how Mark's going to liaise with Richard, and again the future. And the question is, what is Project Craig Marsh? And the understanding of everybody apparently has always been, and your pleading, is that that's a sale. And that's perfectly logical, as the judge said, when you get to 6. But if it's not the sale, then that's a completely different thing, and we'd need to know what exactly it was said this agreement meant. But at the moment, I just don't see how you get there by saying that it's all because the word success fee means something different. I mean, it's the words on completion of Project Craig Marsh, I'm sorry, I keep on calling it Kate, Project Craig Marsh, that matters, isn't it?
Well, but my lord, the point that I've obviously been inadequately trying to express is that in project paragraph 6, the terminology used was not intended to be the sole means by which the 2% would be triggered, and that.
Well, I mean, you can't. It's a funny thing to say. I mean, when you have something that is the written terms that express the agreement between the party, most lawyers say, well, you look at it and see what it means, don't they?
Yes, and could it mean, my lord, that whilst you would be paid the 2% on completion of Project Craig Marsh, it wasn't barring being paid the 2% on other means of securing the success, the separation of interest.
So what are the words that how do we construe, do you say, the words a success fee on the completion of Project Craig Marsh? I mean, just to interject, this is why the judge laid great emphasis on the fact there was no claim for rectification or a claim based on estoppel. So there was no claim based on a shared subjective understanding between the parties that in fact it wasn't just Project Craig Marsh, it was also any separation of interests. So that aside, that being the premise, how, as Madeline said, what as lawyers, do we make of these words? How are we to expressly construe them?
Well, in my expressed submission, we construe so that it's not, you don't read into them only. That was what, it's set out here because that was the expected way it was going to be done, not because that was the only way.
Yeah, well, it would have to say more.
Well,
if you had the words only, which Mr. Rabinovitz, I suspect, would say are OTOs, because there is only one option here, you have to go on to say what else, in what other circumstances would there be not only an entitlement but an obligation to pay the 2%?
Well, I mean, as I say, my lady, the point that we say is that whilst I have to accept, as I did at the very outset, the words in paragraph 6 are there, and I can't go behind it, the understanding of those words is not what has been said against us and found by the judge, namely that this should be treated like a normal success fee, that you only do it by the way stated and by no other route. And if I can just finish off, I know my lord has indicated that you may not find it particularly helpful, but never put off making a bad point and continuing to make it. I just want to finish the success fee, because I started by saying it is a fee that incentivises and informs the person who might benefit by it what he needs to do to pull out all the stops to get maybe an inflated fee. In this case, on the very terms of the touch agreement, he's been told to pull back.
But what about 5?
5, my lady. Look, before we get to 5, I'll deal with 5 in a moment. But he's been told to pull back, and then 4 is expressed. Mark has not and will not give any form of commitment to Anthony that he will not appoint Richard through touch to be his commercial advisor for Project Craig Marsh, and at an appropriate moment wants to do so. So it is plain and evident that the person who's supposedly to be incentivised to get Project Marsh, Craig Marsh, over the line and the sale achieved is somebody that, at the very least, Anthony Bamford doesn't want to have anything to do with the process. And then, as my lady pointed out, paragraph 5, well, following on from what's said in paragraph 4, to be his commercial advisor, that's Mark's commercial advisor, what is happening in 5 is that Richard is being appointed to advise Mark on his interests, Mark's interests, in the development, negotiation, etc. He is not at the coalface of the sale of JCB.
But he is providing. He is to provide future services related to the sale.
He's to provide services to Mark,
Yes.
about Mark's interests.
Yes.
But going back to the ordinary understanding of what a success fee is about, where one holds them very strictly to you achieve that or you don't get home, we say here he's not at the coalface of negotiating the actual sale. He isn't responsible. You can't say it's his success any more than a failure to achieve it is his failure. He's not there. So,
yeah, I see that point actually, Mr. McGrath. But what what I find difficulty with is the whole thrust of paragraphs 3, 4, and 5, and then really 6, is that Project Craig Marsh is the sale, because the last sentence of 4 is about when Richard is to be, when this sort of, I don't know what it is, but when the assurance is coming into effect. And that's when an investment bank is to be formally appointed to handle the sale of JCB Group, or when the beneficiaries of the trust have first consulted on the Project Craig Marsh plan and made themselves appoint their own advisors. So I mean, it doesn't look as if it's talking about separation of interests. It looks as if it's talking about a formal instruction of investment bankers and then consultation for the sale. It then goes on to say when Mark appoints Richard, they'll ensure that Richard is available on an exclusive basis to advise on his interests in the development, negotiation, implementation and completion of the sale, and then you get a payment. I mean, it's all of a piece, and coming back to the point that I was attracted to a little while ago about the first sentence of paragraph 3, perhaps the reason why you accepted that Craig Marsh was the sale is because of the words "and in addition," which the first part of the dog's dinner, if we can put that sentence in that way as you described it, the first part is looking back to 1, 2, and the second part is looking forward to the sale. So the agreement actually hangs quite a lot together. And I know you say, well, he's not actually incentivized. It's a good point. I mean, you're right. He's not the person. He's not the agent. He's not the estate agent selling the house who gets a big fee. But that's because the background to all this is he's done a lot of work already. And there's all sorts of family disputes about who gets on with whom and who wants who involved with what. But why isn't the agreement just the simple form that really the judge said, and that it looks like it all hangs together?
Well, you made an interesting point about it. I mean, several interesting points, of course. But you made a point that he's being paid because of the work he's done already, and that we say is important to appreciate, because that work is all about the separation of interests, and that's why.
Yeah, but so what? I mean, I can do some work for you, sort of free, gratis, and for nothing, all about, planting flowers in your garden, and then you say, look, you've done all this work, thanks very much, and now I'm going to sell my house. And if I sell my house, I'll pay you for the work you did planting the flowers in the garden on the basis of 1% of the sale of the house. I mean, you might do that. What's it got to do with what the words mean?
Well, because we've taken it, and it was as presented to the judge that the measure of success was the separation of the interests under the trust, not whether a sale takes place. That is simply the forerunner route by which. Well, I mean, can I give an example, perhaps simplify it? You want to get to a hotel for a nice family reunion at the weekend. The route by which you take, whether it's helicopter, that's your lifestyle, or train or car, is irrelevant to the success. Or walking, if it's a local hotel. Doesn't matter. The success is getting to the hotel and enjoying the weekend with family, not the route by which you got there. And we look at the sale as simply one route, where there's plan B and other routes have been discussed between the parties to get there, and that what you're rewarding Richard Bamford for is not, as the judge foresaw it, as success fee for getting a sale, but primarily for getting across the line the agreement in June 2011 that Anthony and Mark Bamford's interests should be separated, and that the reason 4, 5 and 6 are referring to Project Craig Marsh is that was put forward as the forerunner of the way in which those interests would in fact be separated, but it isn't and wasn't considered to be the only route. But it's been set down, and now it's been interpreted as being the only route.
Can I just talk around that for a moment? You had a contractual entitlement to be paid £250 an hour, which you were paid. You calculated that if you had charged £700 an hour, you would have been entitled to a further 400 million. And in fact, Mark Bamford agrees to pay you 2.6 million. Then there's provision for a further 2%, which could be tens of millions. And that is, you accept, do you, dependent on something happening. You may or may not think that it's something that Richard Bamford will have contributed to, but it's dependent on some future event.
Yes, the agreement to separate the interests needs to be facilitated so that the interests are indeed separated.
So the payment of 2% is dependent on a future event. On the terms of this agreement, the future event is the completion of Project Craig Marsh. You say that's wrong. It can become payable on some other event. Well, where do we get that in this agreement?
My Lord, the way I'm inviting the court to read it is not that it's wrong to say you get it on sale of JCB under Project Craig Marsh, but that it's wrong to say that that is the only, that it is the exclusive way, because one recognises that the key issue between Mark Bamford and Richard Bamford was the separation of interests under the trusts, and a recognition shared by them that could be achieved in other ways, and that they had discussed the whole question of Project Craig Marsh failing and Plan B, and therefore it's not suggesting that that you don't get paid on Project Craig Marsh completing, but that is not the only way.
And I mean, this is an obvious point, but where on earth does it say that in here? It says it's paid on the completion of Project Craig Marsh. Where do you get any indication that it's payable on any other event in the terms of the contract?
Well, the indication is the absence of saying it is only on.
You don't need the word only, forgive me for interrupting, but you don't need the word only if there's only one option.
Yes, I mean, I don't mean to be, no.
Do carry on.
What I was going to say, the lady, is that going back to the point where I began, that we're dealing with a non-lawyer here who did not believe by putting it down in these terms that meant that other terms were necessarily excluded. And I would just say, when one looks at Barton and Morris, he'd been the company of 5 out of the 8 appellate judges who, for one reason or another, thought that the agreement reached in that case, if you didn't reach 6.5 million, did not mean you couldn't get something else instead.
But Mr. McGrath, you know, I think you have to deal with what the judge said. I mean, if we, taking the analysis of my lord and my lady and what I've put to you, this case does come down, doesn't it, to an implied term. And I think you accept there are strict rules for an implied term. And it really is no good, I use the term again, making airy-fairy submissions about how it might have been different, they must have been doing this and might have been doing that. You have to literally grapple to get an implied term off the ground here with the judge's view at paragraph 86 that the term proposed is not necessary to make the contract work, and it's not so obvious that it goes without saying, nor is it necessary to give the contract business efficacy. And in 87, it would, to do so would involve substituting the agreement which the parties have in fact made by their express terms with a different and wider trigger which they haven't agreed. And at 88, it's far from obvious that the 2% would have been readily agreed as appropriate, whatever the form of restructuring. Now, those are findings which, speaking only for myself, at least at first sight, appear pretty orthodox in terms of what an implied term, making an implied term. So, you know, at one stage I thought you were going further than implied term and saying that there was some contract made by conduct which had to be tried in order to be taken into account in construing the written agreement. But I don't think you are saying that. I think what you are saying is all this background is taken into account to imply a term. Now, why is the judge wrong to have said those four simple things which any judge in the commercial court or the business and property courts or this court or frankly any court understands because we've been brought up with them?
Well, look, on the question of which one I would place my hat on, it is on paragraph 8688 insofar as he deals with it on the officious bystander test.
But you say the officious bystander, if they'd said, of course you'll get the 2%, not only if there's a sale, but if the interests are separated, they would all have said yes.
On the basis of the officious bystander properly informed of the background between Mark and Richard Bamford. The importance...
Sorry, say that again?
Of being properly... It's not just somebody looking at this agreement and saying what flows from the agreement. It's being properly informed of what those involved in the agreement knew when they were entering into this. So they have that information in their hands or in their head. And that comes down to understanding that the raison d'etre between Richard Bamford and the advisory services he provided to Mark was and remained at all times the separation of those interests. That's what he was all about. So the fact that they've come up with a plan to use the sale as the means of effecting it, had these two individuals been asked in their capacity as officious bystander, been asked, well, would I get my 2%? Would Richard get his 2%?
I mean, that's really rewriting the contract. I mean, that's where Barton becomes a problem for you.
In what way, my lord, if one reads into it that the benchmark of success is the separation of interests and not simply just whether or not there's a sale, and one recognises that the sale isn't the exclusive and sole means of determining...
That's putting too much emphasis on the words of the description of the fee. I mean, it says pay to touch a success fee, in other words, money, equal to 2%, but when is on the completion of Project Craig Marsh. So you, to get rid of those words, you've got to go a long way. And what I'm concerned about is that the officious bystander test has never been interpreted to mean, you know, if the contract is, I agree to pay you £5 if you walk from London to Manchester, okay, will you pay £5 if I walk to Leeds? And that's a different contract. That's not what the officious bystander test is all about.
And that's not my case, though. My case, let me put my case in the form of the hotel. I'll pay you to come to the hotel and sing for the weekend at my family reunion.
You won't enjoy it.
Then I may not pay you very much. But how you get there, well, if I go by train, I don't really care how you go. Be there 7 o'clock sharp in a good voice. That's what we're not in the case where we're asking to accept something less. In the Barton scenario, you got your 6.5 million or more. Someone saying I want to be paid, but I haven't achieved the level that we've agreed.
Yeah, but aren't you in the scenario of wanting to get paid for something different?
Well, that then is the implied term, isn't it? Whether or not you are getting paid for something different, or whether you're recognising that the JCB sale it's simply one means of affecting the success, which it remains the same, which is the actual separation of interests, however one gets there.
I know I'm asking you a lot of questions, Mr. McGrath, but can I just go back to the test you want us to apply for the officious bystander test, so I'm clear? The O, of course, and you say the person has to be properly informed of the background. The relevant background, you say, is an understanding that the raison d'etre of Richard and his advisory services was towards a separation of the interests between Anthony and Mark, and you rely on the briefing note of the 15th of June. Is that it?
No, that's not it, my lady. Can I...
What do you rely on? But what is the relevant factual background, do you say, for the purpose of the officious bystander test?
Can we go to the supplemental bundle?
Yes.
Tab 12. And these are typed up notes, contemporaneous notes of Richard Bamford of conversations.
Well, there was a rolling document, was he, that he updated contemporaneously?
By handwritten notes, and these were typed up, I think, for the purposes of litigation.
So we've got the 14th and the 17th.
And you've got the 17th. You've seen that Mark Bamford, midway through 17th, Mark Bamford reaffirms that his key points are he will drop the litigation in exchange for separate trusts and go forward to do Project Craig Marsh. It's all about the bigger picture. Now... Sorry,
Michael, where are we?
My lady, 17th of June, the last entry.
Yes,
on
thank you. Yes.
69,
yes.
Midway through.
Yep.
And then we do have the entry on the 14th of June that your ladyship referred to.
Yep.
There's a complete separation of his trusts, and going forward together, brother and brother, to do Project Craig Marsh. And then on the 19th, one turns over the page 70, second paragraph of 19 of June, the first entry. We talked about the mechanics to separate the trusts, and this is a conversation between Mark and Richard Bamford. And on being asked by me, Mark Bamford confirmed that APP and TL, as Tim Ledbetter, the chap that was in attendance in the meeting, had not shared at the meeting that they'd already had a QC opinion that stated it was impossible to separate the trusts, and if that was the case, then the deal would have to be renegotiated. It would be null and void. And what I just stressed there, and your ladyship will have seen reference to that phrase null and void before in confidential bundle. And I just wanted to show the importance of the separation of trusts to the arrangement reached.
So going back to I think I may unusually have been right. It's the broad headline that the raison d'etre was separation of trusts. That's the relevant factual background.
Yes.
You've gone to the detail. And that is the background against which the O, of course, question and answer are put. Okay.
And while we're on this document, I'd refer to the characterisation of the 2.6 million in paragraph 1 as an advance or down payment, and on page 71 and the entry for the 29th of June, you see there that there was discussion of a down payment of 4 million, and I appreciate that we said, well, the negotiation
this is in the inadmissible category.
Well, I'm not relying on it, my lady, for justifying why we got to 2.6 from 4 or who was right, but that it's considered, it's in the context of a down payment.
Hang on. Richard to Mark, a draft. One draft was with a down payment of 4 million. Why is that admissible and why is it relevant?
Well, it's not. What's relevant out of this is not the discussion on negotiation from 4 to a particular figure of 2.6, but 2.6 is the figure that they ended up at. as reflected in the paragraph 1 of the touch agreement. And all I was saying to your ladyship is that I'd described it as an advance payment or down payment, and I just was showing you this attendance note to show that that was how it was characterised in the discussions between the parties.
The judge decided that was all inadmissible.
Well, I don't know actually what he did decide on that,
Right, okay.
because he didn't tell us what he didn't include. He told us pre-contractual negotiations he thought were out, but I don't know what he excluded expressly by reference to that general statement.
But for your purposes, those are the points you want to draw out of
From
those
those
discussions.
attendants,
All right,
absolutely.
thank you.
But why does that really help? We come back to whether a term is to be implied or inferred in relation to the express terms of the touch agreement. We apply the conventional tests. Why does the question of whether the 2.6 million was to be a down payment against the sum that would become payable on a future event help?
I go back to because it was argued against me that one needed to keep the two payments completely separate and recognise therefore the paragraph 6 is a freestanding success fee based upon the criteria set out there. And all I'm saying here, my lord, with this point on 2.6 million is that in fact the definition of success fee in paragraph 6 includes the 2.6 million, which was itself understood by the parties to be an advance for work already having been done. And that is work done to separate the interests of the trust. So it brings together the payment of the 2% and the separation of the interests of the trust in a way that the approach that paragraph 6 should be seen to be entirely independent of paragraph 1 suggests otherwise.
I'm not sure I really see the point. So be it, the 2.6 is treated as a down payment against the payment that will become due if some further event happens. Why is the officious bystander going to say, oh look, you treated the 2.6 million that is being paid now as something that would be netted off against the future payment if it becomes due. Therefore, we must infer that the future payment will become due on some event other than the success of Project Craig Marsh.
No, but it's part of the process that the agreement 1 and 6 has the connection that wasn't accepted and acknowledged by the court, has a connection. And when one looks at what the officious bystander would say, they are informed by the background information that I've indicated to her ladyship. But also, what's this agreement trying to do? There isn't that distinction between 6 and 1 that's been said. In fact, there is an overlap, and that the 2% is in fact paying very much for work done by Richard Bamford already, the separation of interests and trusts. And that's consistent with the information that, the background information, that what these two parties were trying to do was reward Richard for his participation in and securing of the separation of trusts, which had been the issue between Mark Bamford and Anthony Bamford for many years before. Lord, I'm conscious of the time. Let me just on the second implied term, if I can use that terminology, the made whole good, which was rejected by the judge in 1991. I can be quite short on this because the judge's rejection is premised upon the notion of it being a success fee in the sense that we traditionally understand it, and for the reasons that I've already indicated, the success fee here doesn't operate in that way. One can see how the arrangement about made whole has come about. I think my friend took you to paragraph 27.6, and that's at Call Bundle tab 10, page 168. So we say this isn't one of those situations in which you've reached for the stars, failed to get your 6.5 million, and now you're not going to come back and ask for something halfway through. It was always understood, Richard Bamford would say, that he would be made whole, and that's a reference to the hourly rates that he indicates. But that is very much a fallback insofar as the court's not with me on the main arguments, which we've been discussing.
Well, Mr. Rabinovitz says this is in fact your main argument, but you don't accept that characterisation.
No, because I've just, as the ladies have seen, I've just spent the vast majority of my time trying, successfully or unsuccessfully, to persuade the court of the other point.
And the basis for implication of the second alleged implied term is what? Is it, oh, of course, again?
It is, oh, of course, because there'd been, Richard's evidence is that there'd been many conversations that this would happen. My lady, I've been helpfully reminded by Mr. Legg behind me when you asked about the factual matrix, and it's not necessarily to point to any new documents. You'll have seen, for example, from the 15th of June note that set out the 7 work streams. We predated that, which is supplemental bundle, tab 10, page 65. We predated that to show the complexity of bringing about a deal to separate the interests here, and the need, therefore, for flexibility in how one goes about it. And indeed, you will see in the word flexible there applied directly to the question of Project Craig Marsh. And so there are 7 work streams set out in that document, and one can see that there's an awful lot that needs to be done, and most of that is to do with sorting out the separation of the interests of the trusts. Again, highlighting in my respectful submission that that is the key issue, and the complexity of doing it. The questions that your lordship and ladyship would have seen in the confidential bundle about any consequences of having reached agreements in terms of tax and advice that had been received. They are matters that mean that it is important that you can't assume that it would be in the interest of the parties to have one route and one route only that enables them to overcome all these difficulties. Some nimble footwork might be needed along the way to get them there.
Can I just ask you about something that I should have been clear about before? In terms of the implied terms you allege, I see paragraph 31 of the particulars of claim. That's what you're alleging, is it? Oh, no, you've also, sorry.
No,
we've got the first implied term in
it's 27.5. 27.4, we have the proper construction argument, and then 5 is the implied term.
Is that the first implied term?
First implied term, and then 6 is the second implied term.
And in terms of what being made whole means, I also see 31.2. Is that the same meaning of being made whole or a different meaning?
That's the same. That's why it's in inverted commas. Made whole being bring back up to the 4.5 million.
Now here it's made whole in respect of historic services provided pursuant to the ANZAR agreement. So So those would be services provided before June 2011.
Yes, which are those services referred to in paragraph 1. Include.
It's my fault. I thought this section was all about something completely different. This section's paragraphs 30 and 31 are all about an issue that hasn't arisen, which is whether or not payment would be the mechanics if the trustees didn't do what they were authorised to. So, am I right? 30 and 31 do not arise for us to consider.
I believe that's correct, but made whole is
made whole may be relevant.
Yeah, the same meaning as Lordship understood it, which is the 4.5 and it's 2.6, which leaves the 1.9 million.
I follow. So that the made whole implied term relates to what had happened before June 2011. The shortfall as between the £250 an hour and the larger sum.
Yes, which when one looks at paragraph 1 and the 2.6 million, the importance of it being characterised as an advance payment.
Yes, I see.
Because that had been agreed in the context of being told he was to take a step back, and so wanted some security for payment on those terms. But obviously that made whole would have been swallowed up with the 2% had that occurred, and if it didn't, then
Do we understand you to be abandoning business efficacy? That's the way your submissions today have gone.
My Lord, my Lady, the primary submission and the stronger of the two arguments in my preference submission is the one I put the case on.
So you're not abandoning business efficacy?
Not formally abandoning it, because if the understanding of the arrangement is as we say it is, then the term is necessary in order to make that contract work. Because otherwise, it then gives a status to sale trigger that was not what the parties intended.
I mean, just to be clear, you're saying that the term is to be implied on the premise that it is so obvious that it goes without saying, right? In the context of the factual background. That's your case. And I mean, sometimes when terms are so obvious that they go without saying, they're obvious because nothing is said about it. But here, something, I mean, do you accept that something is said which is contradictory to what is so obvious as to go without saying? Or do you say that because of your interpretation of the word success fee, it's not contradictory?
Well, I don't accept that there's an inconsistency or contradiction between the wording in paragraph 6 and the implication of the term on this basis, because, as I've already...
Because of that interpretation.
Because of that interpretation, and because of the understanding, which would be part of the bystander's understanding, that the sale trigger isn't to be the only.
Well, the bystanders, it's not relevant what the bystander thinks. It's only relevant what the parties would have answered to the bystander's question. And the bystander's question might be motivated by what he thought, but that's irrelevant. What's relevant is the answer. And you say, if the bystander had said, is it a term of this agreement that you will pay 2% on the separation of the interests of Anthony and Mark Bamford, the answer to that would have been yes, it's obvious that that's what we intended.
Yes.
Yeah. Okay. Good.
Well, let's consist you further.
No, well, thank you very much, Mr. McGrath. We'll just take 2 minutes. Yes, Mr. Benefits.
Great, my lords, my lady. As the court knows, my learned friends have made four grounds. The first one relates to 2 points about the correct approach to contractual interpretation. That is to say, what do you do if you have an informal contract and is the analysis different? The second point, which is made under that head, is a Plusnik and Nagel and Remunich point, which is what do you do if the contract is made on a basis where, as events turn out, something unforeseen happens, in other words, event outrun the contract. And those are the 2 points made in relation to ground one. I'm going to leave those for later. Ground two is about factual matrix, on the basis that the learned judge got factual matrix wrong. He did it on the basis of the pleadings and having regard to the witness statements there, and he didn't wait till trial. I'll come back to factual matrix as well. Ground three, which I think is the ground my learned friend spent most of his time on, although he did obviously touch on factual matrix, relates to the interpretation of the contract, the language of the contract and the like. And
Well, it's the implied term.
including the implied term. And subject to the court, I was proposing to start on interpretation of the contract and then move to the others, because one needs to see the language. And with that in mind, can I invite the court to go back to tab 11, where you have the contract? I can take it fairly quickly because the court has, in effect, made all of the points I was going to make. Just this, if I may start, it's well established by this court, Lady Justice Arden in the Carr and Carr case, that even where you have an oral contract, you interpret it in precisely the same way you would a written contract. Certainly where you have an oral contract which is put down in writing, so in effect you have a written contract, again, the ordinary construction or interpretation rules apply. And I say that, and if I'm going too fast, if I'm saying this too fast, please slow me down. What the ordinary construction interpretation rules apply, as the learned judge noted at the outset of his judgment, where he set out all the recent authorities, is it involves, in effect, looking at three main things, or three things. Number one, and most importantly, is the language used by the parties in the written document. Number two is factual matrix, because you should never look at language without context, and you need to understand the context in which the language is used. And number three is commercial common sense, because if you produce an interpretation which makes no commercial sense, then something has gone wrong somewhere. But the starting point, and indeed usually the end point, is the language used, because we are not in a world of Alice in Wonderland, hearing submissions from Humpty Dumpty, where words simply mean what I want them to mean. Words can be ambiguous, but there is an elasticity to them. In the end, they do mean what they say. And in my respectful submission, that is worth bearing in mind when you look at this agreement, because in our respectful submission, as the learned judge found, it's...
the judge went through these three points in turn.
He went through in detail. I should have said at the outset, we respectfully submit that this appeal should be dismissed for very substantially the reasons given by the judge. I only say very substantially because you'll have seen we have a respondent's notice. But with respect, if the judge is right in the reasons he's given, then our respondent's notice doesn't arise. The respondent's notice is the point about 2012. Project Craig Marsh is defined by reference to a time period. That's the same 2012. But as I say, if the judge is right, it really doesn't matter. I also ought to have said at the outset that the point I'm going to deal with first, the interpretation point, is dealt with in the contra skeleton at paragraph 52, and in our skeleton at paragraphs 19 to 34. That's at core tab 3, pages 34 to 42. Now, if I can, as I say, ask the court to go back to the contract, just going through it. It does have, as my lord the master roll says, a very clearly defined structure. And it's, with respect, I don't know if it would like to describe it as a dog's dinner, but it's a structure which actually makes sense.
Well, in only one sentence he said was a dog's dinner, and
okay.
I'm afraid I am guilty of perpetuating that terrible, terrible term.
I'm going to take you through. Can I just again repeat points the court has already made? There is no rectification claim here. There is no estoppel claim. As my learned friend knows, although his submissions didn't always reflect this, the subjective understanding of the parties is irrelevant. That's all Hornbook well-established law. What matters is the object, what a reasonable person would understand these words objectively to me. in the context, obviously. So, just going through this, paragraph 1, MB will now authorise BTCL to pay from the MB Trust a success fee of 2.6 million for the services of RB up to and including the settlement reached between MB and AB on the 17th of June. That is backward looking. This is made on the 1st of July 2011. That is looking to work that has already been done, and it is a success because there has been a settlement. It makes perfect sense, with respect, to talk about this as a success fee because success has been achieved. And Richard Bamford is being paid 2.6 million for his past work. Now, I'm going to mention a point which I'll have to come back to. The court already picked this up. Richard has a point which we have to accept on the basis that we've gone forward. We accept everything he says. That he feels he should have been paid 4.5 million. And as a result, feels that in respect of all the work, he's out of pocket by, I think it is 1.9 million. I'm going to come and develop this point later when we get to commercial common sense. But if my learned friend's interpretation of this is right, the lordships would have seen, the court would have seen from the pleadings that the JCB shares on the learned friend's case had a value of 30 billion pounds.
30 billion?
30 billion. 2% of that is 30 million pounds. Sorry, 3 billion pounds. Sorry. 3 billion.
No, 2% of 30 billion is definitely not 3 billion.
2% is 3 billion, and 2%
half
of that is
30 million.
Of half of that is 30 million. So that's as good as it once was. So on the learned friend's construction, in circumstances where Richard thought he really should have got 1.9 million further, he was in this contract, if there was a sale, going to get 30 million pounds. And in due course I'm going to ask whether that makes commercial sense.
But isn't that your case?
It is. In my case,
I mean, on your
it's
case,
huge.
if there was a sale, then Richard Bamford
Huge
gets
amount of
30
money.
million.
but your lordship needs to understand that my learned friend did not highlight, but it's clear from his pleadings. His case is, at the time this contract was made, the obligation to pay the 30 million, in fact, had arisen because the success was in relation to the settlement. And all that, the only point of difference between paragraphs 1 and paragraph 6 was a timing point. You get the down payment, as he calls it now, 2.6, and you get the further 27.4 later on.
So upon implementation of the settlement,
Precisely.
in terms of separation.
Implementation, and that's why he says it doesn't really matter which way, how you implement the settlement. Could be Craig Marsh, could be something else. But he wants another 27 million, 27.4 million. And this, he says,
Sorry, forgive me. So he wants another 20. He wants the extra money, although nothing's changed.
Exactly.
Is the way you put it.
That's how we put it. In fact, it's a fact. That is his case. But just going back to the contract, so you have paragraph 1, which is backward looking and looks to something which has been concluded successfully, which is settlement. Paragraph 2, Richard will step back from advising Mark as he works directly with McFarlane's to document and implement the terms of the settlements. It's still on the settlement, which is expected to be completed by the 31st of December 2011. And the time is relevant to this sense because that gets completed on the 31st of December. Project Craig Marsh is expected to take place and be concluded in 2012.
So that's a point you say mean Project Craig Marsh can't mean implementation of the
Same
settlement.
thing. And then 3, as my Lord the Master of Rolls pointed out, makes that even clearer because it says this: MB will continue to privately brief RB on progress towards that completion, that's to say the completion of the settlement. And in addition, so splitting it up into these 2 events, the steps being taken to prepare the JCB group for sale in 2012, Project Craig Marsh. MB will also, whenever he feels it appropriate, give assurance to Anthony regarding MB having used Richard as commercial advisor because there was ill will. But just pausing at 3 to reiterate the point that my Lord the Master of the Rolls made, these are two separate events, settlement and Project Craig Marsh. Then 4, AB has accepted that MB will have to have his own advisors for the sale in due course. MB has not and will not give any form of commitment that he will not appoint Richard through touch to be his commercial advisor for Project Craig Marsh, and at the appropriate time Mark wants to do so.
I want to understand that sentence. I don't really understand it. It's actually the only unclear sentence in the agreement. I don't think it matters, but do you have a explanation?
My Lord, the background is this. Richard was seen as a troublemaker, certainly by Anthony.
By
Anthony.
Right.
He was in Mark's ear, and so far as Anthony could see it, causing family problems. And so Anthony was hostile to Richard. And I think what the sentence is trying to get across is Richard wanting to be sure that Mark was not going to agree with Anthony not to appoint Richard. Does that assist, my Lord? Because I can add to that if necessary. Well, Mark, so then this, Mark expects us to be when either an investment bank is due to be formally appointed to handle the sale of the JCB Group. So again, when he'd be appointed to Project Craig Marsh, you see an investment bank and it's to do with the sale, or when the beneficiaries of the trust are first consulted on the Project Craig Marsh plan and may themselves appoint their own advisors. Now, it may be that they didn't need formally to be told about it or consulted, but obviously it was perceived by these two contracting parties, they may have been completely wrong, that it made sense for the beneficiaries whose interests were going to be disposed of to be told about it. Then you get 5. When Mark appoints Richard, Touch will ensure that Richard is available to Mark on an exclusive basis to advise on all Mark's interests in the development, negotiation, implementation and completion of Project Craig Marsh. Just pausing there, the structure of this contract so far has been paragraph 1 deals with settlement, paragraph 2 deals with settlement, paragraph 3 has this pivot, it deals backwards with settlement and moves forward to Project Craig Marsh, the sale. And then paragraphs 4, 5 and 6 are all to do with Project Craig Marsh, not to do with the settlement. And paragraph 5, again, the court drew this to my learned friend's attention, so I won't take long over it, is the work that Richard is expected to do in relation to Project Craig Marsh. Development, negotiation, implementation and completion of Project Craig Marsh, he's going to advise Mark on that. And then obviously paragraph 6, in consideration of these services, that's the services in paragraph 5. They're all related to Project Craig Marsh. Mark will take all necessary steps to authorise BTCL, or if applicable, any replacement trustee of the trust, to pay to Touch a success fee on the completion of Project Craig Marsh equal to 2% of the value attributed to the 50% shareholding of the JCB Group held, less the sum paid. Now, as the court knows, the learned judge, I think between paragraphs 55 and 82, but really primarily 61, analysed this language and came to the conclusion that, in fact, the words meant what they said, and that where the contract made clear that a fee would only be paid on completion of Project Craig Marsh, that is what they meant. And not only did the learned judge come to that conclusion, but my learned friends in their skeleton accept that on the language, that is the conclusion to which he should have come. And you may not recall this, but if I can invite you to go to paragraph 29 of their skeleton argument, so that it's call tab 2.
Sorry, which paragraph again?
Paragraph 29.
29.
Of their skeleton. Call tab 2, page 16. The appellant does not fault the analysis of the judge at paragraphs 55 to 60 that as a matter of textual analysis alone, without reference to the relevant factual matrix or commercial considerations or the purpose of the agreement, the Touch agreement appears to limit payment of the 2% fee to a sale of the JCB Group in 2012. which is what the words mean. Now,
Well, I mean, the problem for Mr. McGrath may be that he's tried to place meaning in slight contravention of that paragraph on the word success fee.
my lord is right, but with respect, placing meaning on the words success fee don't really get him anywhere, or doesn't really get him anywhere. As soon as one appreciates that they do both mean success, but they're talking about different successes. The first, paragraph 1, is talking about a success in getting a settlement. And that's why Richard, who is the person who drafted this, used the word success. He's being incredibly well paid for this. There had been a success. He wanted and was going to get, and indeed has got, 2.6 million. He uses success in paragraph 6 again, because if there is a sale, then it's Project Craig Marsh has produced a successful outcome, which is a sale.
It's just, you could say, in traditional sense, success fee is for incentivization. So there is something to be said there, but nevertheless, I mean, you can use it in a number of different ways, and you say here, it's a success fee in each case.
Well, it's a success. My lady is right. Of course, you can use it in that way, and you can use it for the purposes of incentivization, but it doesn't have to be used in that way. Here, the basis upon which this was contract was made was that they were going to aim to achieve a sale. And that was uncertain. Indeed, it's common ground that it was uncertain. I'm going to take you to it because it's the main point in factual matrix. So, yes, where a sale was uncertain, if it was achieved, that was a success. And Richard would have been involved in the sense that he'd have been advising Mark to achieve what Mark apparently wanted to achieve, which was a sale. And in that sense, again, success meant exactly what it said.
Now, I think the point that Mr. McGrath was making was that it wasn't the normal kind of success fee where you're incentivized to do all you possibly can, pull all the stops out to bring about the event for which the success is to be paid. And in this case, he's not actually doing that. He's going to be available, as we see, to help at paragraph 5. But actually, as you point out, the success has already occurred for what he says it's about. And it's really only something that somebody else is going to bring about if it means completion.
It means completion, exactly. Now, so in our respectful submission, as the learned judge found, the language is clear. It's common ground there was no sale, has been no sale.
Has been a
no sale.
No sale. No. But your case on the point about success fee is that this is an agreement, is it? That where whatever went before, whatever discussions took place, really doesn't matter. The terms are clear. Richard was going to be paid in respect of services for which he'd already been paid something, and for services going forward. I mean, whether and or doesn't really matter. He was going to be paid if, but only if, there was a sale.
Indeed.
And that's that.
Indeed. So
and he agreed to that.
And he agreed to it.
Irrespective of the fact that he was conscious that, if you like, the discussion in the past had been simply about bringing about the separation, but that had already occurred.
Well, it had occurred, and things
Or
were moving on.
it had occurred in principle.
It had occurred in principle. It needed to be implemented. But what came out of that was a project called Project Craig Marsh, which was going to be a sale. If that happened, he was really going to be in the money.
He was going to be in the money.
Yeah. Very substantially in the money.
But it didn't happen.
But it didn't happen. And in terms of what had been discussed thereafter, I mean, as your lordship will appreciate, nothing I'm saying is not entirely in accord with ordinary conventional principles. In circumstances where there's no rectification claim, no estoppel claim, most of these things happen in the context of negotiations and are, for that reason, inadmissible. And when we get to, and although it's right, when one comes to the factual matrix, that you have to have a look at the factual matrix in order to see the context in which this contract was made. That doesn't properly count as factual matrix. But as I shall be submitting, there is nothing in the factual matrix which leads you to a different conclusion.
Well, that may be the resting point. But, sorry, what doesn't properly count as factual matrix?
What was said in the context of pre-contractual negotiations, or what might have been said.
The judge proceeded on the basis that what Richard was told by Mark as to what Mark had agreed with Anthony at any stage was relevant factual matrix.
That is relevant factual matrix.
Even if it was in the course of pre-contractual negotiations.
And with respect, I entirely accept that. And I accept that.
Yes, so you'll come, no doubt, to the bit on the 19th of June, or is it the 20th, or later, the 29th of June,
which is the down
reference
payment.
to the down payment point. Would you say that is admissible or inadmissible?
So it's inadmissible and irrelevant.
Yeah.
There's no rectification claim, which there'd have to be.
All right.
Well, that's a good point to pause. How long do you expect to be this afternoon?
I'm going to try and be as economic as possible. And
Economy is always appreciated.
I understand that, my lord. I will try and finish within an hour or less.
Okay. Very good. We look forward to seeing you in Turkey.